And so tomorrow is D-Day. The Supreme Court has fixed tomorrow to hear the case of Honorable Emeka Ihedioha, who is asking that the Supreme Court review its earlier judgment, which saw him out of office. We're going to be asking two gentlemen here to intervene on the matter. We have with us Mr. Mark Adebayo, who's the chairman of KOWA Party and also the spokesperson of CUPP. You're welcome to Sunrise Daily.
Thank you so much, Mark.
We also have with us Mr. Eina Onwegbu, who is the Publicity Secretary of the APC Caretaker Committee in Imo State and also a legal practitioner. You're welcome to Sunrise Daily.
Thank you for having me. Good morning, viewers.
Well, both of you have seen how matters have played out in Imo State in particular. The judgment which saw the current governor in office, Senator Hope Uzodimma, was greeted with a lot of protest, particularly by members of the opposition party, and as a result, they have gone back to the Supreme Court saying that certain facts were not made available to the Supreme Court, hence the judgment it reached. But they are saying that based on those facts which they are now presenting, they're asking for a review of the judgment. What is your take on the matter?
Well, I think the first thing would be to clear some misconceptions about the application they filed. If the application is aimed at achieving a review, the Supreme Court rules set out what review means. Review means to arrange a further hearing to clarify the intention of the judgment, to make it clearer and plain. That is why the clause on review says to correct clerical mistakes and slip. The rules do not allow to achieve an opposite direction or opposite destination to what the judgment that was read intended. That is one. Now, in the application, they are saying review. They are talking also of setting aside the judgment. It is not allowed to set aside the judgment because they are using the provisions of the General Civil Law to interpret specific legislation, the Electoral Act and its operation, provided for in our laws. In the election petition matters, there is a time frame. 180 days to finish at the local tribunal, 60 days to finish at the Court of Appeal, 60 days to finish at the Supreme Court. Once the judgment of the Supreme Court comes, it's a spent matter. The power to review would only be to correct clerical mistakes, if there are, or slip, or probably when a judgment was ab initio obtained by fraud. Now, in the case they are talking about, they are expecting, poorly advised, that the Supreme Court will start re-examining documents tendered and admitted, even without opposition, at the lower tribunal, discussed by the Court of Appeal, and positions made by the Supreme Court. The Supreme Court is not a place where you start considering what is the figures on a document tendered by the lower tribunal, tendered at the lower tribunal. Now, in this case, the lower tribunal admitted the results that are in question, 388 polling unit results. The petitioner in his case stated these 388 polling unit results were excluded by the collation at the World Collation Center. Not that there was a problem at the polling units. The events at the polling units took a natural turn and were completed, and results issued to us. Now, the lower tribunal admitted those results. The respondents did not say elections never took place in those 388. That was not their case. The respondents did not set up another result to say, contrary to what petitioner is saying, this is the result of those 388. The respondent did not say these 388 polling unit results, if added, would still fail to achieve the constitutional threshold of two-thirds. That was not their defense. So coming to the Supreme Court now to manufacture things they agreed to at the tribunal, they consented to at the Court of Appeal, for which there were no grounds of appeal ab initio, is like a marketplace of shopping. You can't have a second.
I want to ask you quickly, has this ever happened before, that the Supreme Court will sit and reverse itself?
No, the Supreme Court had, in certain cases, Johnson's case, civil action, said this judgment we reached, we did not consider this law. We have now seen this law, and we want to correct our position.
That was not a clerical matter.
No.
That was a
the law. It is called per incuriam, when a judgment is reached without looking at the law. But in this application, nobody's quarreling about the law. What they are quarreling about is the facts used, just like the tribunal that said...
They're quarreling, there's a point of contention right
Yes,
now, which
yes.
is the constitutional spread. There's the argument that neither party, it would seem, have been able to achieve the constitutional spread, even if you go on with the Supreme Court's addition of the 388 polling units. Your current candidate, the current governor, still does not have the constitutional spread to make him the governor.
With due respect to him, it's entirely based on ignorance. The petition that led to this matter clearly stated that if the 388 polling unit results are added, distinguished Senator Hope Uzodimma would have made a spread in 2/3, more than 2/3, that is 19 out of 27. It was stated. Nobody denied it. Nobody presented contrary evidence to it. The lower tribunal made a finding admitting those 388 polling units results. In this era of copy and paste, they are not made by INEC. It was not part of the case. There were no grounds of appeal on this. Nobody challenged his qualification.
Let me ask Mr. Adebayo what he thinks of this. Now the Supreme Court has agreed to review. It's definitely a huge step, isn't it? Mm-hmm. What do you make? What do you think could happen tomorrow? Or what would you expect to happen tomorrow?
First and foremost, let me start by agreeing with Professor Shidi Odinkalu that concludes that Nigeria cannot afford to replace INEC's tyranny with judicial imponderability. And there are actually a lot of complicated imponderables in this Supreme Court judgment. And I do not believe, if we allow this kind of travesty of justice in terms of our electoral processes to stand, we are digging the grave of our democracy.
What exactly was the travesty of justice?
Okay, for instance, if you look at the calculations and the tabulations of the election, in terms of registered voters, in terms of accredited voters on that day, and in terms of the total number of votes cast as recorded by INEC, which is legally and constitutionally empowered to conduct elections in this country, you discover that there's a lot of discrepancies. Almost 130,000 additional votes were added by the Supreme Court, and you wonder how did that come about? If you had accredited voters of about 823,000.
Are you contesting the powers of the Supreme Court to add the figures, or you're contesting the figures? Which one of them?
I am contesting both, because the figures don't add up, and the Supreme Court has no right whatsoever to add to any numbers as presented to it by the EMB, the election management body of the country. So, you cannot, the Supreme Court is not supposed to tamper with any of the figures as presented by the EMPs. You cannot add, you cannot subtract. If they say 823,000 got accredited out of 2.2 million registered voters in Igbo State, how did you come about over 900,000 voters? How did you come about that? Once the number of accredited voters, is lower than the number declared, then there was fraud. There must be something, seriously that have happened in between. You cannot have 823,000 people accredited and then have 925,000 as the total result that came out of the Supreme Court. Where did you get the almost 130,000 votes? Where did those come from?
So what are you hoping will happen tomorrow?
I'm hoping very sincerely that their lordships will be candid and patriotic enough to reverse this. I think the middle level solution to this will have been a rerun in Imo State. Imo State is more or less, it's almost personal to our party, KOWA party, because we also suffered. Look at the result. You will discover that the current governor, Hope Uzodimma, all the evidences, all the results he provided, how come, out of 70 governorship candidates, including KOWA party, how come that it's only APC and PDP figures that are in the paper submitted? How come? What happened to the remaining 68? So, there are curious imponderables in this matter that we need to really interrogate if we really want to save our democracy.
But your party is not in court, are you?
Exactly.
We are in court because...
You're not contesting the fact that your figures were not presented.
No, that's what I'm saying. We are in court on Imo issue, but not on the governorship. On the basis of the fact that our party was illegally registered by INEC, not considering the fact that we won a councillorship election in Imo State. you know, and we consider that to be unjust. That's why we are in court. You know, we consider that to be illegal and unconstitutional. That's why Imo State presents a very, very great interest to KOWA party.
Okay.
And that's one of the major reasons why I agreed to come out to discuss this.
Let's quickly go to Lagos now. My colleagues have questions for you. Gentlemen.
At what point, and I think I'd like to ask the APC man, what are you hoping for at this point now? Because if the Supreme Court comes up with figures, with arguments, what exactly are you looking to happen now? Because definitely, this review is happening tomorrow. What are your expectations?
Well, the first thing is to quickly apologize to my noble loss at the Supreme Court. The Supreme Court does not add figures to anybody. The Supreme Court deals with figures that were compiled, pleaded, answered to, and put in issue from the tribunal to the Court of Appeal. As to tomorrow, what we are expecting is that the Supreme Court would look at the merits of the application, which, by the grace of God, has been presented by lawyers on both sides, that nobody would consider cheap lawyers or weak lawyers. But the important thing is the sanctity of the authority of the Supreme Court has been brought to the marketplace of gossip and accusations by mobilized crowds, whether in Lagos or in Imo or in Abuja. The important thing is that the intention of the Supreme Court in the judgment of 14th has never been misinterpreted or misplaced. The attempt to bring figures, not figures provided even by INEC, is chasing shadows. Is academic because the facts of this matter have been settled effectively by the judgment, not only of the Supreme Court, by the Court of Appeal that declared that the candidate of PDP was competent to tender the results, and that the police officer was also competent to tender the results as received in duplicate originals by the court.
Let me jump in and ask you. Let me ask you this, Mr. Inaya, and Mr. Adebayo will also respond to the same question. So, but you first, Mr. Inaya, what do you say to those who say, first of all, was INEC given the opportunity? Because if you're going to subpoena someone, why didn't they subpoena INEC, who were the original custodians or who those documents are supposed to have originated from? Why a police officer was he even in all of those polling units? How come he's the one who had it?
No, thank you very much. INEC was ab initio a party in the case. INEC was the second respondent, third respondent. INEC had a duty as a respondent to provide an answer to the petition of the petitioner. And INEC agreed in their answer that elections took place in those 388 polling units. INEC agreed when they saw the tabulation of the figures of those results. INEC neglected, whether by any curious twist of fate or by any negligence of professionals, INEC did not provide an alternative pleading to say, contrary to what the petitioner said, this table represents the genuine results of the 388. INEC had the opportunity of cross-examining the witnesses of the petitioners. INEC only attempted belatedly to provide what we call incident form 48 to answer to the 388 polling unit results.
All right. All right. Let me also get Mr. Adebayo to respond to the same question. Go ahead, please, Mr. Adebayo.
To say that the subpoena to the police was as a secondary...
Minute. Hang on. Let's get Mr. Adebayo to equally respond to the same question. Mr. Adebayo, do you agree with what he said?
On the area of where he said INEC did not respond, it's part of the institutional feelings that we are expressing in this country. So if you critically interrogate the processes of this litigation concerning this case, we will come to the conclusion that we will discover that INEC has failed in some areas. INEC wasn't up to his game in this matter. But one thing we cannot accept, that we should not accept as a nation, is the injustices that are embedded in the process of the election and the process of litigation and the outcome thereof. So that is my own major concern. If the court refused to address the results given by INEC and only to depend on the third party, which is the police, I do not believe that that kind of result is credible. I do not believe it's credible. I do not believe it should be admitted, as a credible evidence in law by the court. I do not believe so, because if your figures do not tally, the total vote do not tally with number of accredited voters, the best the court should have done would be to order a rerun of that election, so that everybody goes back to the field, and then there will be a clearer election, a cleaner election, a more credible process that will be admissible by the Nigerian populace. So it is not. The outcome. The outcome was suspect. The outcome was somehow, for me, it's like standing the law on its head, standing democracy on its head. If you look at it critically. Whether they consider the figures or not, if you interrogate the figures, you will discover that there is a huge credibility issue concerning the Imo State election. Huge credibility issue. Because whether somebody says...
Yeah. Okay, just a quick one. Mr. Inaya, would anything be wrong if there were to be a rerun? Would your party be scared to get back in the ring?
No, there's a misconception, because when you go to a tribunal, you ask for the prayers you desire. The question is, at the tribunal, did any party ask for a rerun? For example, there are issues about results from Mbise Nation. Abon Mbise accredited voters, 24,000, results 64,000. Nobody's talking about that. The important thing is that if there were no prayers on rerun at the tribunal, will you expect the Supreme Court to now be Father Christmas, to continue giving out cherries for anybody who wishes to bite as many times as possible? No. The Supreme Court is a court of record from the lower courts, and the Supreme Court unfairly is being dragged into the probably mistakes that were made by the respondents in the case. These respondents even refused to call witnesses to defend their position. They did not file a cross petition to challenge the two-third claim we made as petitioner, which we proved in the court.
You're not answering the question. The question is, if the Supreme Court does order one, will you participate?
No, I am saying that the Supreme Court will not, because the issue of rerun was not a case from the beginning.
I oftentimes...
We don't answer speculative questions of if in court.
Indeed, but yes. you have said that nobody asked for a rerun.
Yes.
But there have been cases where the Supreme Court or any court of law might see that what is actually needed to solve the problem here will be a rerun. If indeed, maybe with new facts presented or whatever it is that, it's going to be reviewed tomorrow, they find out that there is a need for a rerun, would you participate?
No. There wouldn't be a rerun, because the case does not tolerate of a rerun.
You do not envisage that there could be
yes, I do not envisage
a
there will be a rerun, because the Supreme Court is not coming to give what was not asked for at the tribunal. The Supreme Court is being asked to look at if there is a slip in what they did on 14th of January.
Let me ask Mr. Adebayo now. Do you think that there could... what you're expecting tomorrow will be a rerun? Is that what you're expecting that will be ordered?
One would expect justice to be done.
Justice for you will mean what?
Will mean that the current status quo should be overturned. And that the best that the Supreme Court could do for this country, assuming without considering that probably the legal team of the governor, of the former governor, did not do their job, assuming without considering that INEC did not do his job, assuming without considering that probably the Supreme Court did not have all of facts available to it, I would expect their lordships to do justice tomorrow by ordering a rerun. That's the minimally. Because, if you look at it, people, analysts, including lawyers, have broken down this situation and said that neither of the candidates even met up with the required 25% in the 2/3 of the local government of the state.
Which he has said was not raised in any of the courts.
Well, if that wasn't raised, then that should be, because the former governor's team
wasn't a former governor.
was looking at something else. Maybe that's why they did not raise. I'm not a lawyer.
Yes.
The technicalities of all these things.
Whose fault is that, if they were not looking there?
Well, it will be the fault of the legal team. But more importantly, it will be the fault of the processes if all these things were not taken into consideration. We need to integrate. Where did almost 130,000 votes, where did it come from? Where did it come from? How come from the number of accredited voters of 823,743, how come did we arrive at 953,180 votes? we need to interrogate that.
Well, gentlemen, I'm sorry,
can
we're,
just take it.
we're totally out of time. I wish I could give you more time to respond, but we are out of time. I have to thank you both for coming to share your thoughts on the matter tomorrow as we look to the Supreme Court for the review, which is going to come up with on the Imo governorship elections. Mark Adebayo is the chairman of KOWA Party and spokesperson of CUPP. Thank you for coming.
Thank you.
And Eina Onwegbu is the publicity secretary of the Imo State APC Caretaker Committee. Sunrise
Thank you
Delivery.
for having me.
Yeah, thank you for coming.
Have a blessed day.
Sunrise Delivery will continue in a moment. For your comments, please stay with us.
Let's have a look at some of the messages you have sent in response to some of the issues we discussed this morning. We'll start with this one from Badon Joshua. He's talking about security. He says, security challenges only need a proactive approach in tackling them. But what we see today is the reverse. No government will sit comfortably when lives they took an oath to protect are being taken on a daily basis. The government should devise a means and do the needful, he says.
Well, Zemo tweets about calls for sack of service chiefs, and this is what he has to say. Why can't we march to the government house in Abuja and protest against the myriads of problems facing us as a nation? Why pick out just the service chiefs as the bane of the security problems? Definitely, this has a political undertone, says Zemo.
Well, Naijama is speaking on the same subject of the planned protest. Disturbing to hear Ben Kalu tweet on Sunrise Daily Now saying that Nigerians who want to demonstrate over service chiefs should get police permission. Can it be that a lawmaker does not know the position of the law on the constitutionally guaranteed right to freedom of assembly? That's Naijama asking.
And this is from Tokes Idris Oladende, who says on national security, service chiefs actually just a little spoke in the will of Nigerian security. What of population, food security, economy, corruption, mismanagement, unemployment, religious ideologies, politics, population growth, national security strategy, desertification? I guess it's all that spokes in the will of security in Nigeria. That's according to Tokes Idris Oladende.
So there you go. That is the show today. Thank you all for watching and for your comments. We'll see you tomorrow. I'm Chamberlain Uso.
Don't forget, you can also watch on YouTube this live and then other episodes. Our channel is at Channels Television. I'm Kaido Kikyolu.
I'm Ayo. Makine, have a wonderful day.
And I'm Maupe Ogun Yusuf. Thank you for watching.